So one thing I want to let you know is that these are the bill. They are not the law yet, and this could change depending on the further consultations and feedbacks from the community. So in these meetings, we have a number of topics that we want to cover that is mentioned in the bill. So that comes from access to planning, to plan reassessment, payment, and automations. There will be an opportunity for questions in the end after our speakers make their presentations. So the first topic is about access to the NDIS. So one of the biggest changes in the bill is the functional capacity will be defined for the will be defined in the Act. So functional capacity seems to be quite similar, which I will discuss in the details. And another changes in the bill is that the rules can actually effectively limit who can be considered for access before applying the legislative test. And another thing is the bill also increased the time that NDIA can make a decision. So it's up to 90 days as opposed to 21 days. Another big change proposed in the bill is the new definition of permanence. So the functional capacity definitions seems to be quite similar to what we understand under the current law. But one of the biggest uncertainty around the bill is how the ministers can make the rules. So the rules hasn't been announced yet, so we don't know if the meaning of functional capacity would change. So the reason why the change in the definition around access is because the Minister Butler says he wants to remove 160,000 people from NDIS. So these rules will be an important part of how they will do that. Some of the things will be fall into this will be including what might be used to assess function capacity, what severity level that people may be eligible, and what type of information or evidence can be relied by assessor um, or by medical professionals. So based on the commentary that we have heard from the media, we can assume that this would be focused about children, about which who can remain on the scheme, and also assessment tools that would be used for different types of people with disability. The bill also proposed to change the definition of permanency. So currently, the test for permanency is if the person has explored all available evidence-based and appropriate treatments. Now, with this one, they have changed to treatments to all appropriate treatments, which defines as if it's evidence-based, can be reliable, be expected to materially improve the person's conditions, and is regularly offered in Australia. Why is this a big changes? Because this applies to the person's circumstances. This applies regardless of the person's circumstances. For example, whether they can afford it or whether there is limited opportunity for the treatments. And the bill also changed the early intervention criteria from a mitigating to alleviating the impact of the person's impairments to benefit the person's reducing the impact of the person's impairment. This new definition could potentially cause delay for people with degenerative conditions, and they may not able to access NDIS until they meet the disability requirements, which potentially reducing the quality of life. Planning and impairments. So one of the ways we can demonstrate how this bill would change the NDIS is used in this case study. So Mit al, he is blind, and the NDIS has granted access on that basis. Al has also have a range of other conditions that means they need to use a wheelchair when they use the home. The NDI do not agree that these conditions meets access. Likewise, Al also has psychosocial disability. The NDI do not agree this condition meets access. So how does this look in planning? So currently, that NDI plan has to look into the notes, and the notes requires the NDI planner to consider our speech impairments when developing the plan. This note also means that the planner must take into account of our physical and psychosocial disabilities when considering disability support that ours needs. What the current bill does is that they totally remove the notes that is used to make the plan that is being used today. And instead, that section 34(1)AA now refers to a support needs arising directly from impairments of or impairments that meet the access. So and also the bill also try to increase exclusion, including impairment caused by a car accident and work-related injuries. Because there is other scheme that covers it, for example, like TAC. So this is a big things about planning, because this bill strips out what support is required by the person, because we know that disability can be complex and there is multiple impairments that defines what support the person needs. This is going to be tricky because it's going to be a huge responsibility for the participants to prove there is a direct link of the support to the disability. And it is a shame because there's no gender analysis here, and there will be particularly disadvantage to women, as they're likely to have conditions which the medical professionals doesn't understand well, and the NDI will not accept it without vote. While we're on the subject of the principles that the bill removes, the bill intends to change that we would change the principle that the support has to be reasonably necessary so far it is consistent with the financial sustainability of the scheme. This is particularly important because the principles will guide how the law should be interpreted. So currently what I have on this slide is what outlines the principle which decision making needs to take into account, and that includes numbers of wonderful things that gives choice and control for the participants, such as the plan is to be individualized, directed by participants, control over their own lives, and choice and independence. But what this bill does, it removes everything, almost everything. There is a couple of sections, including C, CA, and F, that will eventually find its way back in other sections of the bill. But you can say that the bill basically removes the principles. This will it will be difficult for the decision makers or tribunals or the courts to interpret how to apply the NDIS legislation. Once the principle has been gone, there is also support determinations. So let's see what's happening instead. The first thing is the support determination allows the government to reduce the funding for the certain categories of funding on a collective basis. For example, a 20% cut to social and community participations funding for all participants with a certain characteristics. This will also be there could be also disability types, age, location, or something else. It could be also be all participants, and that is one of the decisions that the ministers for NDIS can make under the proposed bill. So basically, the NDIS minister will have a lot more powers under the bill than they had before. The bill mentioned that it safeguards, which states, in making a determination, the minister must have regards to the safety of the participants. But the problem here is the bill doesn't explain how this will be done. In addition to the powers that the bill proposed to give to the minister, the minister can also make determination for support or class of supports in relation to participants generally or class of participants. So what basically this bill allows the minister is to set a cap of how much funding that a type of participants or specific type of the participants, which means like so it can be made, there will be a maximum amount of therapy fundings for people with autism, or limit assisted technology budgets for people who need assisted technologies and others. And this bill also will create a cost cutting for the planners, such as, are there any cheaper alternatives? But they don't need to consider whether it achieves the same outcome. They also need to consider whether leasing would be cheaper than buying. And then we also will consider what research and evidence is there of effectiveness. And also they will consider presumption of parents are responsible for providing substantial care and support for children. Now we're going to plan assessment and renewal and suspension. So the bill also proposed to restrict the participants' ability to make a reassessment request. So previously that can be done by change of circumstances. Now the participant only can request a reassessment if the certain conditions applies. The agency also can refuse to reassess, and if the agency refuses to reassess, this is no longer a reviewable decision. Sorry, there will be no deemed decision if they haven't made a decision within 90 days under the current bill. And because there's no deemed refusal, that means that it cannot be reviewed and applied to administrative review tribunal. Also, another changes that the bill proposed is that they remove rollovers and instead it will introduce renewal. This includes the old plan will be ended and the new one will start the next day. Unused funding that's been used in the old plan will not continue to the new plan, and the new features will be incorporated, such as new funding periods, support determination, and maximum fundings, etc. One of the features in that bill is that NDI also can suspend the plan if the participant has not if the participant remains uncontactable for 90 days. So this could be another problem. What if contacting participant is inaccessible, or if the person is making inquiries but is stuck in the call center? And for planning claiming, there is a change in the bill that the claim must be made within 90 days. Participants must keep a record of the claims and payments for 3 years, and nominees must keep a record of the claims and payments for 5 years. And plan management will fundamentally change. So under the new bills, we can expect there will be far smaller pools of plan managers who must have signed an agreement with the NDIA. the plan manager will not be allowed to provide any other support to the participants. Plan managers will need to tell the NDI about other companies that are related to, such as if they're owned by the same people. Automations. The NDI will be able to automate certain decisions. For the moment, they're focused on the plan with productions and payments. That's the current focus. But then there will be some changes about support determinations, automations, which is going to be essential to flow all this part of the relevant budgets. But what about the information that automation is relying on deciding how to apply determination and why can the participants see and review it? And this would be the most important part of information that recognize the disability impairments, and which you can see that on the portal and app. So this is a bit concerning because the participants may not be aware what is information is on the system that the data relies on for automations. So there would be a couple of issues in automations, but including support determinations won't be written into the plans. So the plans may say $50,000 in funding, but there is $30,000 available. So for example, they may say the participant has $50,000 in therapy fundings, but only $30,000 is available for specific types of therapies, but it's not written on a plan. So how would the participant know they have the funding available for that type of therapies? If you also reach the end of the plan and renewal occurs, it will bring all the new features in, such as funding periods, support determination, etc. A renewal is not a reviewable decision, so this means it cannot be appealed to ART under the current bill. And also, another question that we had is, would suspensions be automated? What happens if the participants actually call or email the contact center, but nobody got back to them? Because we cannot be sure how the NDI keeps the record. So this is one of the burning questions that we have about the bill. So I'm just going to move on to my co-presenters. As I said, we will have a question and discussion at the end of the presentation. And just for information for about Villamanta Disability Rights Legal Service. Now I will pass on the presentation to our wonderful Kirstie.
Oh, thank you, Victor. Good afternoon, everyone, and I just want to say thank you very much for having me, and it's a real honor to be here talking to you guys this afternoon. My name is Kirstie Shaw, and I work as a counsellor, disability advocate, and disability and inclusion clinician. I work really closely with neurodivergent individuals, families, and support systems across disability, education, health, and community settings. Alongside my professional work, I am also a parent of neurodivergent children, and I'm also navigating these disability systems and other systems personally as well. So I bring that lived experience to my work and understanding. So for me, these conversations are not abstract. They are professional, systemic, and deeply personal all at once. Next, thank you, Victor. William and I would like to acknowledge disability and neurodivergent advocates, families, LGBTQ, IQA, and COLD communities, and all of those advancing human rights. And we also acknowledge the traditional custodians of country and pay our respects to elders past and present. So today I want to focus on the gendered impact of the proposed NDIS reforms and why many women across disability, care and community services are deeply concerned about the direction that these legislative changes are taking. Because the reality is this, the NDIS is already failing many women in significant ways, and many of the proposed reforms risk intensifying harms that women with disabilities, mothers, carers, and female disability workers are already carrying every day. I understand the government's stated concerns around scheme sustainability, consistency, and fraud prevention, and those are, legitimate policy discussions. But legislation cannot only be assessed through projected savings or administrative efficiency. It also needs to be assessed by who carries the practical burden of reform, whose participation and safety are affected, and whether the reforms remain consistent with Australia's human rights obligations. Historically, disability systems have often remained sustainable by relying heavily on unpaid, mostly female labour. And when supports become harder to access, women disproportionately absorb the consequences. So the NDIS was intended to function as a rights-based framework aligned with the United Nations Convention on the Rights of Persons with Disabilities, or the UNCRPD. The National Disability Insurance Scheme Act 2013 specifically refers to supporting independence and social and economic participation, enabling choice and control, supporting inclusion and participation in community life, and giving effect to Australia's obligations under the UNCRPD, which we are signatories to. And that matters because human rights obligations do not disappear during periods of fiscal restraint, particularly obligations connected to Article 6, regarding women with disabilities, Article 19 regarding independent living and community participation, Article 16 regarding protection from violence, exploitation and abuse, and Article 28 regarding adequate standards of living and social protection. These rights are not abstract concepts. They directly affect whether people can safely participate in ordinary life. So, women with disabilities already experience disproportionately high rates of poverty, family and sexual violence, and housing insecurity, underemployment, social isolation, chronic health dismissal, and unpaid care expectations. And many women already experience barriers accessing appropriate disability support because disability in women is frequently under-recognised or misunderstood. And that's particularly for neurodivergent women. Hi. Many women spend years masking difficulties in order to survive socially and professionally, only to be later viewed as too articulate, too functional, or coping too well. So when we discuss tighter eligibility interpretations, increased reassessments, and narrower funding definitions, these reforms are not occurring inside neutral systems. They are occurring inside systems that already disadvantage women. So public discussion around the reforms has largely focused on sustainability, fraud prevention, consistency, and tightening access. But legislation does not exist in theory. It shapes access to support, safety, participation, and autonomy. So the proposed reforms introduce or expand mechanisms, including, as Victor touched on, narrow interpretation of what constitutes NDIS supports, increased reassessments and review powers, tighter restrictions around funding categories, stronger reliance on foundational supports, which means broader community-based disability supports outside of individualised NDIS funding, increased emphasis on informal or natural supports, well, we all know where that goes, expanded compliance and investigative powers, and expanded powers for government to determine what supports can and cannot be funded under the scheme. So these changes are likely to disproportionately affect people with the least financial security, the least informal support, and the highest levels of functional complexity, particularly women. Because support needs do not simply disappear because the legislation narrows eligibility or shifts responsibility elsewhere. The labour's transferred, most often onto women, and some amazing men as well. When support hours are reduced, women frequently fill the gap. When disabled children cannot safely remain regulated in school environments, mothers reduce their employment or leave the workforce. When systems become harder to navigate, women absorb the administrative burden, and many women are already operating beyond sustainable capacity before these reforms even have the chance to occur. So, Community-based, sorry, next slide, Victor. So, where are we? Community-based foundational supports may play an important role within the broader disability system, but they're not equivalent to individualized legislative protected supports tailored to complex functional needs. And that distinction matters because many disabled people require consistent individualized assistance in order to maintain housing, access education and employment, manage daily living, safely participate in community life and avoid crisis and institutional escalation. So when supports become increasingly discretionary, restricted, or administratively difficult to access, rights become harder to practically exercise and enforce. At the same time, the increasing emphasis on natural supports raises serious concerns because we need to ask sorry, Victor, I messed up the slides. Could you go to the next one? Thank you. At the same time, because we need to ask, who exactly are these natural supports? In practice, it's overwhelmingly women, mothers, partners, grandmothers, sisters, daughters. Women already spend enormous amounts of unpaid time coordinating appointments, navigating reassessments, advocating across systems. And I don't say this to exclude men, I just say it because the majority of this work falls to women. We're also compensating for workforce shortages and preventing breakdown of support arrangements. If reforms increase reliance on informal care while reducing funded supports, responsibility is effectively being transferred back onto unpaid women inside private homes, and this is not gender neutral policy. So the next slide, Victor. Supports such as community participation, psychosocial supports, support workers, capacity building, and daily living supports are increasingly being framed publicly as optional or excessive. But for many women, these supports are preventative and protective. At a recent rally, I heard an anonymous speaker who shared that the only reason they were able to identify and safely leave an increasingly coercive and financially abusive and controlling family violence situation was because of their NDIS support workers. As their world became smaller, these workers remained consistent and they reduced isolation, maintained community connection, created visibility outside of the abusive environment, and became trusted people in a situation where dependence and control were escalating. So that continuity of external support for her increased safety and reduced isolation. And this directly intersects with Article 16 of the UNCRPD regarding protection from violence, exploitation, and abuse. For many disabled women, support workers are not just practical assistance, they're part of safeguarding infrastructure. And reducing supports does not reduce vulnerability. In many cases, it will increase it. So, the other thing is that women also make up a significant proportion of the disability workforce. So, support workers, therapists, peer workers, advocates, community sector staff. Many are already working inside systems that are under substantial strain. So when funding is reduced, workers don't stop seeing need. They're simply left managing increasing complexities and risk with fewer safe options available, which contributes to burnout, workforce attrition, reduced continuity of care, unstable support environments, increased systemic risk for disabled people themselves. Professionally, I see the impact of system instability on women constantly. I see mothers operating under extraordinary levels of administrative, emotional, and financial pressure while trying to hold together increasingly fragmented support systems. I see disabled women struggling to access support because they don't fit the narrow expectations of what disability is supposed to look like. And I see the psychological impact that develops when people are forced to repeatedly justify their support needs inside systems that are becoming increasingly restrictive and suspicious. Personally, I also understand the exhaustion of navigating systems that often require families to become coordinators, advocates, and crisis managers simply to maintain basic stability, because the people most affected by these potential reforms are not policy abstractions. They're families trying to maintain safety, participation, housing, education, and well-being within systems that are already difficult to navigate before additional restrictions are introduced. So the NDIS was built around the principle of choice and control. But choice and control are meaningless without actual access to support. A person cannot exercise autonomy if they're isolated, unsupported, financially trapped, or permanently operating in survival mode. And women cannot continue functioning as the invisible shock absorbers for systemic failure while governments simultaneously promote workforce participation and gender equality. Because every hour of unpaid care is transferred back onto women is an hour removed from employment, education, financial independence, health, rest, safety, participation in community life. I think I might have missed how this actually impacts me as a parent as well. So I just wanted to say that, it's not abstract for me. Um, it's something that deeply um, affects me personally as well. And sorry, I'm just going to go and find my little bit about that. No, I can't. It's all right. Sorry, guys. So I'm just going to go back to what I was um, speaking about. So the question that we should be asking, oh, yeah, so sorry, I'm speaking today. Thank you, Victor. I'm speaking today as a counsellor, a disability advocate, a clinician, and a parent navigating disability systems personally. And I'm also somebody who has also struggled with the idea of potentially accessing support for myself, because I know that that is going to be very costly for me emotionally, mentally, and also physically as well. And the question that we should be asking at the end of the day is not simply whether the NDIS is financially sustainable. The question is whether these reforms are largely are legally, ethically, and socially sustainable. Because a rights-based disability system cannot remain rights-based if access to participation, safety, and autonomy becomes increasingly conditional, restrictive, or dependent on unpaid, informal care, particularly when that burden is disproportionately transferred onto women behind closed doors. So yeah, sorry. Thank you so much for
Thank
having
you,
me.
Katie. In the interest of time, I think we just going to move on, but thank you for your time to present um, this powerful message. So
Thank
I
you
will
so
hand
much.
to William, who will be doing the presentation.
Thank you so much to both Victor and for Kirstie for their incredible speeches before I've started to yap away at this time in the afternoon. So I'll try and keep it brief for most of you because I can imagine most of us are tired. As Kirstie mentioned, there's a lot of effort going into this space, and I think yeah, all we can do is be there for each other. So thank you for having me this afternoon, Villamanta, and thank you everyone for coming to this forum. My name's Ward-Boas. I'm here as the chair of VALID, which is the Victorian Advocacy League for Individuals with Disability. I'm speaking both today from a lived experience perspective as an ADHD person with disability, intellectual disability, and numerous other titles because I'm a cocktail of labels at this point. And I'm also part of Rainbow Mob as well, proudly. So I'm happy to be representing those intersections as well as my professional and personal capacity. So before I get into it, I just wanted to reassure people I'm not just speaking out of my ass when I speak here today. I've got a 7-year experience in the disability advocacy sector, in the non-for-profit space, and in the state-based non-for-profit, state-based government, national and international spaces. I'm the current chair of Valid, as I mentioned. That's why I'm primarily here, but I'm also in different roles as the board member for Inclusive Rainbow Voices. And I'm also here as a community visitor under the Disability Act here in Victoria. And I also was an attendee of the United Nations Conference of State Parties in 2024 and will be returning this year. So at the core of disability rights, I think it's best to say that they are human rights too, to us. That is not simply a slogan or a nice statement to people to put on websites. It's a framework that Australia has already committed to through the UN Convention on the Rights of People with Disability. But one of the uncomfortable truths we also have to sit with is that Australia still does not have a National Human Rights Act or a National Bill of Rights. And that matters a lot because people with disability experience harm, exclusion, unfair treatment within these systems like NDIS. And this is no single unified rights framework that consistently holds government to all systems to account in a comprehensive way. Instead, people are often left navigating the fragmented complaint systems, tribunal legal pathways, and advocacy services that are not equally accessible for everyone. Communities are already under pressure. So before we even talk about reform, we need to acknowledge the reality that people are already living with people with disability are under pressure all the time. Families are under pressure, carers are under pressure, advocacy and legal services are also under pressure. People are already trying to navigate this increasingly complex, uncertain, and demands within systems that people already find difficult to access. And that pressure becomes felt now across the entire disability community. Slide 5, please, Victor. I want to be very clear about something. Most people want, sorry, tongue twister. I haven't had enough coffee today. Most people are not opposed to reform. People want the NDIS to work better. People want clearer processes, faster decisions, less bureaucracy, fair access, and consistent across all of the systems. And there are concerns that many people have right now, and this is what happens when sustainability becomes a dominant framework and human rights starts moving out of the center of the conversation, because when that happens, people with disability often feel it first, and they feel it deeply. Next slide, please, Victor. Across the community, people are asking very simple questions. Will I lose my supports I rely on? Will my child still be able to access what they need? Will I be able to be safe and independent still? What happens to the supports keeping my life stable? Will they disappear? These are not abstract policy questions. They are everyday realities for people trying to survive inside a system that already feels really uncertain. Next slide, please. From an advocacy perspective, we already know what happens when support becomes harder to access. People lose independence. Families and carers burn out. Mental health deteriorates. Support networks become stretched beyond capacity, hospital admissions increase, and people become increasingly isolated from community life. The impact does not disappear. It simply shifts onto families, hospitals, emergency systems, and unpaired carers. Next slide, please. Another issue is complexity. Because it's more than complicated, the systems become through these kinds of reforms, the harder it becomes for people to understand their rights and exercise them. Some people can read legislation, prepare submissions, or navigate formal processes. Others cannot, not because they have lack of intelligence or insight. It's because these systems themselves are inaccessible inherently. A disability support system should not require legal expertise just to get basic entitlements. Next slide, please. We also need to be really honest about consultation, because consultation is where rights either become real or they remain theoretical. Meaningful consultation may require supported decision-making, plain language, tactile communication, flexible participation, culturally safe engagement, and trauma-informed approaches. If consultation is not accessible from the beginning, it's not great or genuine consultation, it becomes symbolic. So right now, advocacy organizations and grassroots advocates are working across the country during this enormously uncertain time with big amounts of help, and thanks to community and grassroots advocates like a lot of you who are here. So these people are analysing legislation, translating technical language, supporting parliamentary submissions, explaining rights, and bringing lived experience into policy spaces. And they are doing this while advocacy services, legal services, and families themselves are already stretched thin. So nothing about us without us. I also want to acknowledge something really important here. People with disability are not passive in this process. People are organising, speaking publicly, writing submissions, supporting one another, and making sure that lived experience is part of the public record, and that matters. Because nothing about us without us is not just a slogan, it's the principle of the very movement we are all a part of in this reform. So slide 12, please. I also wanted to offer something more practical. I know many people who want to respond to the proposed legislation but feel really overwhelmed by the complexity of how to start or how to turn their experience into a parliamentary submission anonymously or publicly. So support through Valid will be available next week. I will be assisting people personally with parliamentary submissions. So I am offering a in-person day in the Valid office in Naarm from 9 to 5 p.m. on Tuesday next week. And I'm offering online sessions on Monday and Thursday. And just really important to get out there before we get to question time. I'm sorry, I'm yapping a lot. Please do email my email address, william@valid.com.au. Sorry, william@valid.org.au. I should remember my email, hey. And for those who are unfamiliar with Valid, the organisation has a long history of rights-based disability advocacy, peer advocacy, systemic advocacy, and capacity building programs across Victoria in group home settings and others. My final reflection is I want people to leave with this thought. A disability support system should not require legal expertise simply because you need to understand your rights. Human rights cannot become secondary in an administrative inefficiency. And the real question should be asked in this simple way: how do we sustain the NDIS, not us? And what kind of society do we want to be? Thank you so much again to Villamanta, to Kirstie, to all of you in the audience who I know are really staunch advocates in your personal capacity, and some of you who do it just unpaid. Lots of love to all of you in solidarity. Thank you.
Okay. We'll stop sharing screen. So that concludes the presentation. And as promised, we try include the last 10 minutes just to share your thoughts, debrief what's been said, anything. But one thing we need to remember that this is the bill, it's not a law yet. So um, we are working to raise awareness about how this bill will impact many people with disability, including myself as a deaf lawyer and everyone in the forum. So yeah, let's see if we have Q&A that any questions for us.
There's about 4 of them in the Q&A box, and I think I saw a fair few in the chats, but I definitely did not keep up with like the flux of people communicating with each other, which is the
Willie,
miss.
sorry, William, I've just actually seen a comment which is 100% valid, and I would like to apologize if it seemed as though we were potentially not acknowledging the impacts of other particular communities. So I would really like to acknowledge the effort that, the effect that these changes are going to have on our First Nations individuals, which you are one, William, and also our LGBTQIA community, our trans and gender diverse people, and all of the intersections that go into making up our community of people with disabilities. There are lots of the whole thing is just diabolical, and I don't even know where to start. We could be here forever, but I just wanted to acknowledge your comment, Joelle, because that was, yeah, that was really important. So thank you.
Thanks, Kirstie. Victor, did you want to address any of the Q&A?
I'm just having
I couldn't really see any questions. There's just lots of comments and an amazing amount of support. But I also wanted to remind everybody that submissions are due in next Friday, the 29th of May. And as William said, Valid and Villamanta will have information up on how you can receive some support and some help with your submissions if you require it. Otherwise, you can go straight onto the parliamentary website and upload your submissions yourself. I think at the moment there's been 30 submitted. We need more, guys. Let's flood them, because the more submissions they get, the more they're going to know, oh, maybe we shouldn't do this. And also, William, we need to plug our Women's March.
Absolutely. I'm cautious that we've got almost 5 minutes till 5.
Oh, so there's
There's
questions in the Q&A.
about,
Here we go.
yes.
Yeah.
So I believe the presentation will be shared because the slides from the last forum were circulated, I saw. So I assume that will be the case. Victor, is that correct?
Yes, so the recording would be shared and posted on YouTube. But just give us time to upload it.
Victor, we've got here, sorry, George, we'll get to you in a moment. Are there any conflicts between other legislation or strategies and the new bill with examples like the Disability Act or the National Autism Strategy? Was a question we've got here.
Yeah, this is a very, very good question. The truth is, I don't know the answer to it. This is the bill that we are all learning, and that could change in the future. So I don't know if So if this is really necessary aligned with other legislation, it is too early to say at this stage.
I'm a bit of a policy nerd and I might be able to answer part of it if that's okay, Victor. So until we get a national human rights act, which does come inherently with a human rights framework, that will make it very difficult for us to, I guess, link things like the National Autism Strategy to new upcoming initiatives that they come up with, like Thriving Kids and the intersection of the National Autism Strategy. If you read it as I have in my hyperfixation time, there's a lot of inconsistencies and not a lot of linkages to or references to the National Autism Strategy. So until we get a human rights framework, it is just really pretty paperwork, to put it in blunt terms, which is really heartbreaking because I know a lot of people who chaired that work and participated in the working groups. And it's really heartbreaking to know that when they create things like the Thriving Kids initiatives, that they're not even referencing their own paperwork. So, yeah, over to you, George, if you want to ask a question.
Thank you. More comment, just to say that there's a lot of opportunity to learn more about the bill. I know that every thing counts is running a session, and Mary Anderson will be speaking at that, and Belinda, um, Oscar, and Jordan Steele John. That's on the 28th, but have a look at the Every Australian Counts website for that. And I also posted a podcast as well that has some explaining of the bill too. And I just want to say that I want to reinforce that, yeah, we all need to maybe take a bit of time to message our local members, our senators, and also the opposition. So Melissa McIntosh um, and Angus, I forgot his surname, Angus Taylor. um, and they need to hear that there are concerns. And thanks for the session today.
And thank you, Every Australian Counts, for doing the work you do in your spare time too. There's a lot of community forums and sessions that you hold, so that does bring a lot of hope. I just want to vocalize as well, we may not get to all of the questions, and I'm really sorry about that, but if there are questions you did address in the chat or in the Q&A that we don't get to, I assume Villamanta will be taking some questions by email as well. Is that right, Victor?
We can assist with the submissions, but I need to confirm about whether we can answer all the questions. As we said, this bill is just introduced recently. There's a lot of things that we need to learn, and that could change in the future once it goes through the Senate and the proper legal process.
There's a lot of questions around parents and if they're supposed to provide substantial support for their adult children in the changes suggested. And I'm not a lawyer, guys. I wish I was. I was considering doing my Juris Doctor, but I got my master's to finish. Anyway, so I think the idea is that I'm not sure whether there is actually legal wording, but there's a lot of rhetoric around pushing things back onto parental responsibility and, those natural supports or foundational supports. So from what I can see, I think there's going to be a lot of pushback on what constitutes parental responsibility. Before we had the tribunal who upheld, that, our parental responsibility is very different to being a parent of a child with disability, and there was a big acknowledgement of the differences and extra things that we might have to help our children with, but it's gone the other way now. So yeah, we'll try and keep a record of these questions and hopefully we can answer them. Hey, Victor.
Yeah, there's quite a few questions, but unfortunately we are running out of time.
Yeah.
And I'm going to be very honest with you. There's some questions in the chat which I'm unable to provide answers because I don't have information with me.
If you guys wanted to hop onto my page, it's Kirstie Shaw Advocacy. Shoot me your questions, because if I don't know the answer, I'll go and ask people who might and pick their brains for you.
Yeah, same for me. If you want to chuck me a message on my email, which is william@valid.org.au, very easy to remember. I'm more than happy to take questions and I'll answer it the best I can or seek information too.
Yeah, no worries. Maybe we could host a joint live session, William, where people can hop on and ask us questions and stuff. That would be super cool. But also, if you want information about the Women's March, it's on the 21st of June at 2 p.m. across the nation. William and I are actually the co-organisers / captains for Melbourne. So as soon as we finalise the details, we will be letting everyone know where it will be held. We just need to figure out like which space we can book and what's accessible for everybody.
Wonderful. There's lots to look forward to. Thank you so much, everyone, for sparing an hour on your Friday afternoon. It's a big ask to ask anybody to spare the last second of their work week to come to something like this. So it's lovely to see some familiar ones and some new ones. Take care.
Yeah, thanks so much, everyone. You've been the best, most supportive people ever. And thank you so much, Victor and Villamanta, for giving William and I a platform to talk about these specific issues. And yeah, thank you guys. You've been amazing.
Thank you.
Thank you. Sorry, Helen, did you want to say something before we go?
Sorry, mistake. I'm trying to get rid of it. Well done, guys.
Thank you so much.
Sorry, guys, I wish we had more time. Please feel free to hop over onto my page or William's page as well. And yeah, pop your questions over there. And if we've got some time, hopefully we can have a little bit of a yarn on our pages as well. So yeah, thank you guys.
Right. Thank you. Thank you for coming. And I hope this session will be informative for you. And remember, we can speak up if we think there's a problem with the bill.
Yeah, our voices matter. Don't think that you don't have a voice. You do.
Okay. Thank you.